Something important just happened in the courts, and it has the potential to flip how carry laws feel in California almost overnight. Not in a clean, obvious way, not in a way that comes with flashing warning lights, but in the kind of quiet, technical way that catches ordinary people off guard and leaves them facing serious criminal charges, while they're still trying to understand what changed. If you don't understand the difference between a ruling that exists on paper, a rule that is paused, and a law that police are still enforcing on the street, you can accidentally cross a line without ever meaning to. That's the danger moment California is in right now. A lot of people hear words like unconstitutional, overturned, or struck down and assume that means a law is gone instantly. That assumption is where people get hurt. Gun law changes rarely arrive as one simple switch being flipped from off to on. More often, they arrive as a chain reaction. One court decision shakes something loose, lawyers rush to use it in other cases, state officials scramble behind the scenes. Police departments wait for guidance that may or may not come quickly, and during that gap, the public is left guessing. Guessing is how people end up in handcuffs right now. California is in one of those unstable windows where the ground feels like it's shifting beneath your feet, even if you have no interest in open carry, even if you only ever carry concealed, even if your firearm never leaves your vehicle. When courts pull on one thread of a carry law, the entire legal sweater could start to unravel in unpredictable ways. Here's what set this off. Explained in plain language without the legal fog. A federal appeals court ruling from the Ninth Circuit took a serious swing at California's broad ban on open carry, especially as it applies to large, populated counties. That matters because those counties are where most people actually live. Their lives, on the surface, it feels like the state's long-standing rule just got flipped on its head, and that's why emotions spike so fast. But this is the point where people make the most dangerous mistake. They hear that a restriction failed constitutional scrutiny and assume that means it's safe to act immediately. In real life, there are the parallel systems operating at the same time. One is the legal opinion written by judges. The other is the enforcement reality faced by police officers on the street. Those two systems do not always move in sync. In the enforcement world, officers generally enforce what is written in the statute books unless they are clearly ordered not to. Even after a court issues a strong ruling, the state can ask for the decision to be temporarily frozen while it appeals. That freeze is called a stay. A stay is essentially a pause button. It allows the old rule to keep running while the legal fight continues in the background. During that pause, nothing may feel different at all when you're standing on a sidewalk with a holster. This is why celebrating too early can be dangerous. The smart move isn't excitement. The smart move is understanding timing, status, and risk. A court victory does not automatically shield you if the system hasn't officially changed. How the law is being applied. Think about how this plays out for a normal person. You live your life. You're not trying to make a statement. You're not looking to provoke anyone. You want to protect yourself and your family. You see a video or a post claiming that California's open carry ban just collapsed. It sounds definitive, confident, authoritative. You think this is finally your moment. You strap on a holster the way people do in other states. You run a quick errand. Someone notices. They panic. They call 911 and report a person with a gun. Police arrive fast because that's how those calls are treated. You calmly explain that a court ruled the ban unconstitutional. The officer responds that the statute is still on the books and they have not been instructed otherwise. Suddenly, you're on the pavement. Your firearm is seized. You're in a patrol car. Even if you end up being correct months later, the damage is already done. You're dealing with arrest records, legal fees, stress, lost time, and possibly lost employment. Being right later does not erase being arrested now. That's why the most important question is never did gun owners win. The real question is what is being enforced today. A legal win does not protect you until enforcement actually changes. The confusion window right after a major ruling is the most dangerous time. People think the courts move slowly, and often they do, but behavior changes instantly. The moment a decision drops, three things happen at once. Attorneys rush to cite it in other cases, trying to spread the logic into new courtrooms. Government agencies quietly circulate internal guidance, asking their lawyers what they're allowed to do and how much risk they're willing to take. And regular people react emotionally. Some test boundaries, some panic. Media outlets amplify the most extreme interpretations, lawmakers feel pressure to respond quickly. During that period, it is completely possible for the opposite realities to exist at the same time. A judge can write that a restriction likely violates the Constitution, while a police officer still arrests someone under that same restriction. That doesn't mean the officer is malicious. It means officers enforce statutes, not social media summaries. Unless there is a clear, binding order telling them to stop, enforcement often continues. This is why acting on hype is one of the fastest ways to end up in trouble. If you cannot clearly confirm that a ruling is active, final, and not paused, the safest assumption is that the old rule still applies. In court, "I thought it changed" is not a defense. Judges do not excuse violations based on confusion or headlines. California makes this even harder because its carry laws are not a single rule. They are layers stacked on top of each other. State statutes interact with county policies. Permit conditions add another layer. Sensitive place restrictions overlay everything. Federal rules can enter the picture without warning. When a court shifts one piece, the entire structure becomes unstable. One common trap is assuming that all carry is treated the same. Open carry and concealed carry are not just stylistic differences. They often come with different permissions, different location rules, and different penalties. Another trap is believing that a permit is a universal shield. A permit helps, but it does not override every restriction. You can still violate location rules, posted property rules, or zone boundaries without realizing it. The third trap is believing that being legally correct guarantees fair treatment in the moment. The reality is that the process itself can be. The punishment, even a temporary arrest, can change your life. Imagine a scenario that seems harmless. You have a valid permit. You carry responsibly. You go to pick up your child from school. You don't enter the building. You don't step on those school grounds. You wait nearby in your vehicle. What you may not realize is that some areas are governed by invisible boundaries. Zones extend beyond property lines. Mixed-use areas blur definitions. An officer claims you were inside a restricted zone. Now you're not arguing constitutional theory. You're arguing about distances, maps, and technical definitions. That is a fight you never want to be in. As the calendar moves deeper into 2026, another fight becomes even more important: private property carry rules. Some states are pushing for a default rule, where carry is prohibited on private property unless the owner explicitly allows it. That sounds reasonable until you think about daily life. Most places you go are private property. Stores, restaurants, parking lots, shopping centers, even walkways within commercial areas. If the default is no, then carrying becomes a constant guessing game. Guessing creates criminals out of people who have no intention of breaking the law. The alternative approach is a default yes system, where carry is allowed unless the property owner posts a clear prohibition or directly asks you to leave. That model creates clarity. You can see a sign, you can comply, you can leave without incident. The constitutional question is which default respects both property rights and the right to carry. California has already expanded the concept of sensitive places aggressively. If courts allow states to label massive areas as off-limits or to turn private property into a legal minefield, carry can be functionally erased without an outright ban. Instead of saying you cannot carry, the law says you can carry, just not anywhere that matters. That is why these cases matter so much. Modern restrictions don't always look like bans. They look like 1,000 tiny exclusions that add up to the same result. Some states have taken this idea to extremes, making it potentially illegal to carry into a friend's business unless permission is explicitly posted. That isn't about respecting property owners in a traditional sense. It's about using property rules as a tool to suppress carry entirely. Decisions coming out of higher courts in 2026 will either shut down that strategy or give it new life. Once those lines are drawn, states will move fast. Some will ease restrictions. Others will push new ones immediately and dare lawsuits to stop them. In the middle of all this, people keep making the same mistakes. The first is treating social media like a legal authority. Viral clips feel convincing, but they are not court orders. A confident tone does not equal accuracy. If you act on bad information, you carry the risk, not the person who posted it. The second mistake is deliberately testing the edge during peak confusion. Some people want to be first. They want to prove a point. They want to exercise a right. Publicly, there is nothing wrong with valuing rights. But the confusion window is when you are most likely to be arrested, even if the law is about to change. Being a test case means accepting the possibility of years of litigation, massive expense, and permanent public exposure. The third mistake is forgetting how fragmented enforcement can be. California is not uniform. Counties and cities vary in how aggressively they enforce. Cross a state line and the rules can flip instantly. A permit that means one thing in one jurisdiction can mean nothing in another. The goal isn't memorizing every statute in the country. The goal is building a habit of verification before you carry somewhere new. There is a practical way to handle this without being a lawyer. First, separate the existence of a law from its enforcement status. A statute can still exist while enforcement is changing, or vice versa. When you hear about a ruling, ask whether it is active, stayed, or under appeal. If you cannot answer that clearly, behave as though nothing has changed. Second, keep your carry routine boring. Boring is safe. Boring means predictable. Do not add new behavior just because a ruling excites you. Wait for clarity before changing how you carry or where you carry. Third, know your highest stress locations cold. You don't need to memorize everything. Focus on the places that generate the most legal trouble: schools and school zones, government buildings, courts, airports, and clearly posted private property. Fourth, understand that talking can make things worse. In interactions with law enforcement, people often try to explain themselves out of trouble. Sometimes that only adds fuel. Stay calm, be respectful, follow instructions. If the situation escalates, stop discussing details and seek legal counsel. Fifth, track changes responsibly. You don't need to read court filings every day, but you do need a reliable routine. Choose one or two trustworthy sources and check them regularly. When a major ruling drops, check again. In this legal climate, things can change fast. There is also an emotional reality that rarely gets acknowledged. Many responsible gun owners are exhausted. They're tired of shifting rules, tired of feeling like one misstep could ruin everything, tired of doing their best and still feeling targeted. That frustration is understandable, but the legal system does not make allowances for fatigue or confusion. Prosecutors don't care that a headline misled you. Courts don't excuse mistakes because the rules are complicated. That's why discipline matters more than anger or optimism. Discipline means resisting hype. Discipline means treating court opinions as information, not permission, until enforcement is clear. Discipline means protecting your future by protecting your record. The legal landscape will continue to evolve. Courts are increasingly forcing states to justify restrictions using historical standards, and that pressure is not going away. Some laws will fall, some will be rewritten, some will survive. Through all of that, the safest approach remains the same. Stay informed, verify status before acting, and don't confuse a legal argument with street-level reality. In times like this, caution isn't weakness. It's how to make sure that exercising a right today doesn't cost you everything tomorrow.